welcome back to my YouTube channel. My name is Ana Fernandez. I'm an attorney in Miami. And today I wanted to answer a few questions that I've been receiving regarding independent contractors and employees. Now, there is a difference between the two of those, and I would highly recommend that you speak to a local attorney with respect to certain laws and local laws, that is. But really, today I wanted to touch base on certain things that may happen that would cause an independent contractor to then become or be considered an employee in the eyes of the law and the court. Now, this is very important, very, very different. These two roles are very different in the sense that laws and with respect to taxes and also with respect to compensation are going to be different depending on the title of the person. But even if you have a title, let's say if you have the title of an independent contractor, there are some actions and the way that you treat this person with respect to your business that may qualify them as an employee. And that is very important to consider because, let's say, for example, you have someone working for you and as an independent contractor, the terms of your agreement that you have with this person may be for X amount of time. Now, an independent contractor may be considered an employee with respect to, for purposes of employment law, depending on the time. So there's a thin line between independent contractors and employees when it comes to employment law. And you want to make sure that you don't run the risk of having a contractor classified as an employee, because the way that you treat this person, it could later come back and jeopardize you, and you may be responsible for certain compensation and violations of certain laws. Now, the duration of time that you put in an agreement is one of the factors that's going to be considered in the eyes of the court when there is a question of determining whether a specific person is either an employee or an independent contractor. So if you're putting a duration of time that's for several years and this person is supposed to be an independent contractor, then I can see an attorney arguing that this person should be considered an employee because, you know, the way that you're treating this person and the fact that it's a long-term commitment in a way, and that of course factored with other stuff as well. Like if this person is clocking in 9 to 5 type thing and they really have no other time to have any other work, then they may be considered an employee. So you want to look into the length of time. You can get creative with the agreements that you do. You can possibly have a duration of time on a month-to-month basis to be renewed or reviewed at the end of each month. But you want to make sure that you have this classification very clear and you speak to your local attorney for local rules with respect to the difference between independent contractors and employees. And just keep in mind that the length of time that someone is under contract with you is one of the factors. So again, if you put a period of 10 years, 5 years, 3 years, then you run the risk of having that independent contractor being considered an employee. Of course, this comes with other factors that need to be considered as well. So if you have any questions regarding agreements, regarding anything legal in Florida or within the United States, please reach out to us. Let us know, as we are creating content to help better serve our community. Thank you so much.